Okay, we're going to move on. Next up happens to be page 8 of the calendar today, and that's T. Phillips versus Jennifer Abrams et al. Let's go ahead and set forth our appearances for the record.
Good morning, Judge. This is initial T period Matthew Phillips, and I am the plaintiff.
Good morning, sir.
Good morning, Your Honor. Adam Pernsteiner on behalf of defendants Dave Schoen and Mark DiCiero.
Good morning.
Morning, Your Honor. Joseph Garin for Jennifer Abrams and the Abrams Law Firm.
And good morning, sir.
Good morning.
And does that cover all appearances?
Yes, Your Honor.
All right. Just want to make sure I didn't overlook anyone. All right. And okay. And let's go ahead and do we want to have this matter reported?
No, thank you, Judge.
All right. What about from the defense perspective?
No,
On
Your
behalf
Honor.
of Abrams, this is Joe Garin. We do not need this reported, Your Honor.
Okay. All right. I didn't really think so either. Okay. I understand. All right. And so anyway, once again, good morning. And Mr. Phillips, it's my understanding this was your motion to strike. Is that correct, sir?
Yes, Your Honor, that's correct.
Okay. You have the floor, sir.
Well, basically, the defendant's attorneys are defaming the plaintiff in a manner not unlike what the defendants have been doing. These are criminal allegations alleging the plaintiff is practicing law without a license. Well, let me say unequivocally, I know it's kind of hard to maybe to define the practice of law, but the way plaintiff signs his pleadings, nobody relies on that, and certainly nobody relies to their detriment. And the manner in which the signature is affixed, it's not taking a gig away from any local Nevada attorney, so it certainly is not actionable as a practice of law. And defendants have actual knowledge of this. The reason I say it is because they've never filed a state bar complaint. If they thought there were a problem, they would file a state bar complaint. So the question arises, why are they doing this? Well, the truth is they're doing this because they want to continue the smear campaign of the plaintiff. They're doing exactly what their clients are doing. And it's the plaintiff's argument that these allegations are scandalous. Within the meaning of Rule 12F, the court can strike a scandalous matter. I would also say that these allegations about the unauthorized practice of law are irrelevant. And the reason they're irrelevant because they tend to prove nothing in the case. They don't prove any affirmative defense. If the issue is defamation, it's not affirmative defense to say that the plaintiff practices law without a license. It's kind of silly. But the part I find most offensive, and I hope the court frankly will address this, the points and authorities cited by the Lewis Brisbois law firm are just completely, they miss the mark, to put it mildly. They cite an Ohio case where a Kentucky lawyer got in trouble with the state bar and was ultimately disbarred because this attorney purportedly signed his name in Ohio. Well, that's not what the situation is. The attorney didn't get in trouble for signing his name. This Kentucky attorney was in fact representing clients in Ohio and charging them money. The case before the bench right now is totally different because the plaintiff, of course, is self-represented. And just to make this kind of quick here, the reason they're doing this also is I believe they have no viable defenses to the claims, no viable defenses to this lawsuit. And frankly, they're just wasting time trying to paint the picture of the plaintiff as being rogue and miscreant and all those other things. And that's basically it, Your Honor.
Okay, thank you, sir. We'll hear from the defense.
Good morning, Your Honor. Adam Pernsteiner on behalf of Dave Schoen and Mark DiCiero. I would agree this is a waste of the court's time. However, I'd point out this is an issue that's been raised by plaintiff. This is really a holdover argument from the motion to dismiss briefing that the court previously ruled on. in favor of the defendants. These are, plaintiff is referring to prefatory comments that were in the beginning of the briefs as to the fact that his pleadings have been signed and are continued to be signed by an out-of-state law firm, his firm. I believe it's not scandalous for that reference to be made, given that the plaintiff continues to sign his pleadings that way. We have not taken a position as to any bar complaint, despite plaintiff's repeated invitations that we do so. Obviously, there's very good reasons why we do not reference disciplinary proceedings before the court. Nevada has rules on those. So that's why we've ignored those invitations. We think this is not a good use of the court's time, and we don't think it's scandalous to make a remark about something that's undisputedly in the court record. Thank you, Your Honor.
Your Honor, this is Joe Garin for the Abrams defendants. What's troubling to me about plaintiff's insistence that he identify his California bar license in the caption is there's an attempt to somehow let the world know that he's a lawyer and he can practice law. Nevada has some pretty clear rules. For example, Supreme Court Rule 42, which requires that attorneys go through procedures if they want to have a pro hoc admission. Now, I understand that counsel is representing himself, but he's not a lawyer in Nevada, and it's misleading for purposes of the court record to have all that information in there. I don't know why it has to be in there or what it's adding to the case. So there's a collateral concern about the implications under Rule 8.4. So I think the motion should be denied, and the court should instruct plaintiff just to do a typical pro se caption as opposed to the pomp and circumstance of a California license. Thank you, Your Honor.
All right. Mr. Phillips, sir.
Yes, I'd like to just say real briefly that Mr. Pernsteiner said these were passing comments. They're not passing comments. They are pointed allegations, and they're intended as such. I would say also that these pleadings remain in the public record, and even though the arguments are no longer viable because the hearing was disposed, the pleadings still remain in the public record. I would like to point out something that both of my able colleagues somehow missed, and I don't know how they missed it, but if I could turn the court's attention to the pleadings, specifically the upper left-hand portion of the caption page, right below the name, it has a state bar number, and below that it says not licensed in Nevada. And for the benefit of my colleagues, again, not licensed in Nevada. I don't know how anybody could think I was playing hide the ball here or trying to impersonate myself. The reason, if I could be, this might be too much information, I don't know, but many years ago, this must have been 25 years ago, I testified in a fender bender case. And a few moments into the testimony, it came out that I was an attorney. And the judge was mad at me for not immediately identifying myself as an officer of the court. And I was reminded that when an attorney appears before a tribunal, they are supposed to identify themselves. So that is what I'm doing. But there's no pretense of practicing law without a license because, again, for the benefit of my colleagues, it says not licensed in Nevada. This has never been an issue. I've done several cases here in Nevada. That part about the law offices of T. Matthew Phillips is a template. It just comes up on my pleadings, and it's never been an issue in several years of family court litigation, in other private litigation. It's just coming up now because, again, defendants are on a mission to try to slur the good name of T. Matthew Phillips. And with that, Judge, I will rest.
Okay, here's my question for you, sir. And for the record, I don't mind saying this. I did look at the caption in the upper left-hand corner, of the pleadings in this matter, and specifically where it sets forth T. Matthew Phillips, Esquire, California State Bar, and it gives you state bar number, not licensed in Nevada. And here's the thing, and I don't know the answer to this, but and it could be a gray area. From a practical perspective, clearly you have a right to represent yourself. You know, we all know that. I don't necessarily see how this rises to the unauthorized practice of law by having it there, but maybe it could lead to some confusion. I'm not sure. Just as important, too, I see like the signature portion of the pleadings. And, for example, I'm looking at page 2 of the motion, and, of course, it has your electronic signature. It has what would be appropriate as far as you're representing yourself under your name. And then it has the law offices of T. Matthew Phillips, you know. And so my question is this: what does that really add? And then we'll get to another issue. What does that really add to the case? Because to be candid with you, sir, I know you're a lawyer, licensed in California, you know, and I don't know why that judge got mad at you, but I wouldn't get mad at anyone for not disclosing to the court that they were a lawyer. I mean, you know, unless it was germane to the case on some level. And typically, lawyers have a right to represent themselves and defend themselves. You know, we all know that. Just like an average Joe or Jill has that right, too, to do it. And so from a pleading perspective, what does that really add?
Well, if I can anticipate where Your Honor is going, and respectfully, if Your Honor wishes that that portion be excised where it says Law Office of T. Matthew Phillips, I am happy to comply.
Right. Okay. I got you. And my last question for you, sir, and I just want to make sure I understand, because I'm looking here, and the points of authorities are very short. As far as when it comes to striking, the motion to strike, I just want to make sure I understand what portion of, I think it was of the reply, that you wanted stricken from the record.
I think in the reply brief, I'm pulling it up right now, on the last page, we're simply, we indicate the portions that we want to strike, I believe is what it is.
Okay. I want to see. Here, if I missed it. Okay.
Or it may be in the moving papers.
Yeah, okay. But the reason I'm asking that, I'm just wondering, so I have some particularity as far as page and line number.
Yes, it would be defendant's reply brief that was filed on April 6, and this is the defendant's reply brief at page 2, lines 9 through 12, and defendant's reply brief at page 4, lines 5 through 15.
And as far as page 2, lines 9 through 12, what does that say again for the record? I just want to make sure I'm clear.
Okay, let me get it here.
I see here. I got it right here. Matters to be stricken, summary and conclusion.
Yes. And the exact language is on page 4 of the moving papers, where it says, Plaintiff T. Matthew Phillips is a non-Nevada licensed attorney who appears to be engaging in the unauthorized practice of law. And the second, what we believe is offending portion, is the paragraph on page 4 of their brief at lines 5 through 15.
And what does that say?
That says that the absence of an attack by plaintiff raising the issue of the unauthorized practice of law should be deemed by the court to be an admission. The unauthorized practice of law is not an issue to be taken lightly in Nevada, as it carries with it swift penalties.
All right. And after I pointed that out, and sir, thank you for the clarification. After that was pointed out, any comments from the defense on those two issues? as it pertains to the unauthorized practice of law?
Your Honor, Adam Pernsteiner, again, on behalf of Dave Schoen and Mark DiCiero. I do not believe this reaches the level, threshold of what would be needed for a motion to strike to be granted. This is argument in a reply brief that was previously before the court as to signing of pleadings that aren't disputed, that the court's already addressed. I would ask that the motion be denied.
All right, and I think co-counsel from the defense, I just want to hear from you.
Governor, I don't think that this would fall within the unauthorized practice of law as the court defined it in the case of In re Lerner. It's troubling because it's misleading, but for purposes of argument in a pleading, I think that considerations of the litigation privilege truly preclude the court granting this motion. I mean, we're in an adversary system, and if they want to polish their allegations in a certain way, I think they're entitled to do that. I don't think that it necessarily requires a separate Rule 12 motion to strike a pleading that's already been ruled on.
I understand. I do.
Thank you.
And you're welcome, sir. And we'll get Mr. Phillips. You get the last word in our rule.
That's correct.
Well, I would just say real briefly, litigation privilege would insulate them from a lawsuit for defamation. I mean, if this were not in connection with a pleading, I would sue these counsel for defamation because it is defamatory. But that being said, these are criminal allegations. They have no place in the pleading, and respectfully, we would ask the judge to strike and excise those portions.
And all right, and we have a clear record. This is what I'm going to do. And two things. As far as future pleadings, Mr. Phillips, what we're going to do is this. We're going to have you, I want to make sure, we're going to have you take off the law offices of Matthew T. Phillips when you sign it in the future. As far as the specific motion is concerned, as it pertains to the unauthorized practice of law. Interestingly, I was on the State Bar Unauthorized Practice of Law Committee for about 10 years, well before I became a judge. And the way I look at this, and I think this is, we just can't overlook it when it comes to lawyers and professionals. Potentially, it could have a significant impact making that type of allegation. And so, as it pertains to the provisions that specifically point or reference to that, for the record, I'm going to grant the motion and have that stricken. That's what we're going to do. And I'm going to have you, Mr. Phillips, prepare an order, and it's going to be circulated. I just want it written with some findings based upon our discussion. And once you're done, you're going to circulate it to the adverse party, defense counsel. And if you can't, if they can't agree, and maybe not, and if we have a dispute as to the contents of the order, everyone's free to submit competing orders. But it should be a real simple order, Mr. Phillips. And so that'll be my decision on this issue. And so with that in mind, we'll go ahead and move on.
Your Honor, there is one housekeeping item in this case I'd like to raise.
Go ahead.
Address it. There's a June 3rd hearing currently set on the anti-SLAPP motion to dismiss. I believe the court currently has two proposed orders before it from the prior motion to dismiss. Both provide that date will be taken off calendar. I believe as we sit here today, it's still on the calendar, but I just wanted to raise it for the court's attention. I don't believe there's any disagreement between the parties that it would be taken off, given that there'd be presumably a new complaint, at which point there'd be a refiled or a new motion.
All right. And Mr. Phillips, you don't have any objection to that, do you, sir?
No, Your Honor. Thank you.
All right, I didn't think so. In fact, I kind of remember it maybe, I mean, we have a lot of cases, vaguely. It was touched upon at the prior matter. But this is what we'll do as far as the motion to strike, the motion to dismiss pursuant to NRS 41.660, the anti-SLAPP provision, and also motion for summary judgment. We'll vacate that. All right? And someone can prepare someone can. And sir, can you prepare an order for me on that? Just a simple one-liner. Was it's contained in the prior submitted orders? Is that correct, sir?
Yes, it's already before Your Honor in previously submitted orders.
Okay, and that's fine. We don't need a new order then for that. But for the record, we'll vacate it just to make sure that there's no confusion. And that can happen very easily. All right. Everyone enjoy your day.
Thank you, Your
Thank
Honor.
you, Your Honor.
Your Honor.
Okay.